rights which are enshrined. So if a person is asked to forego these three basic rights, he needs to be given a fair hearing. The fair hearing should be again done in a manner known to law. That is, the law which is available, it should be applied. He should be given the chance of being heard fairly, and then the verdict should be rendered. The verdict should be rendered by the tribunal which is not even biased, or which is, you know, above any kind of apprehensions. The due process has also which states that no person can be taken away his property without due payment of compensation. And also regarding the person being put in prison, without a trial, a person can never be put into prison. So these are by and large, that is a fair hearing. In fact, the due process even goes to the extent of stating that no double jeopardy, that is, the person can never be penalized twice for the same offense. That is also enshrined there. And also regarding the American law, if you just see in detail, in the incricities, a person can never be asked
I think there is some network issue. We'll just wait for 2 minutes. Aparna ma'am?
Yes, tell me. I'll find out what. I'll find out.
Ma'am, and I'm going to mute everyone, ma'am. I'm not going to give access to unmute because a lot of disturbances are coming. At the end of the session.
Do that.
Aparna, can you hear me?
Yes, I can hear you. Come in.
Narmada ma'am, just a minute, ma'am. I'm just going to mute everyone and disable the unmute. Yes. Ma'am, can you hear me now, ma'am?
I can hear you, Prithvi.
Yes, ma'am. You can start now, ma'am.
But they're saying they're not able to hear me at all.
No. In between, I think some connection issue, so it went off completely. Now we are all able to hear you, ma'am.
Okay, I want to know where did I stop so that I can start from there. Where they lost me.
Yes, ma'am. You actually, we were at.
All right, I was just defining what is due process. And then I just stated, I will get into the.
Yes, ma'am. You were defining about what is the due process and how does the state has to consider the laws for all the citizens and how they cannot be deprived of it. You were there.
That's right.
Yes.
So I then started by saying that the origin of due process.
Yes, ma'am.
Aparna, can I go ahead? Am I audible?
Ma'am, she is muted.
Prithvi, can I go ahead?
Yes, ma'am. Yes, ma'am.
All right.
We can hear you,
regarding the origin, and it's very surprising note that it all started from England law. And as you all know, the famous Magna Carta, 1215. The infamous, famous King John had a lot of issues with the barons relating to the land holdment, and they had a lot of issues regarding the dispute pertaining to land sharing and stuff like that. So they wanted to kind of have one settlement between among themselves, like more like an arbitration even in those days. So it was signed on the 15th June 1215. That is, King John accepted Magna Carta, and he in fact stated that they will, in fact I can even quote that, the words which are found there, because that's the starting point as far as the due process is concerned. I quote, "No free man shall be seized or imprisoned or stripped of his rights or possessions or outlawed or exiled or deprived of his standing in any other way, nor will we proceed with force against him or send others to do so, except by the lawful judgment of his equals or by the law of the land." Now, stopping here for a moment, I unquote. Stopping here for a moment, two words are very, very significant as far as the Magna Carta due process is concerned. One being the judgments of his equals, and also the land, that is the law of the land. The concept of equals was brought in because always they felt that the kings are above law, and at any point of time anything can be deprived. So they wanted to curb that one problem which they were facing. And also regarding the law of the land. Law of the land means the basic law which was prevalent regarding the relating to their fundamental law. So these two things which are enshrined in the Magna Carta in clause 39. Now, these words which are found there in Magna Carta has had a big walk throughout the Britain in terms of their legislation, I mean, in terms of the judgments rendered by the courts. But if you just see in fact, I missed one important phrase in that. The phrase is, "To no one will we sell, to no one deny or delay right or justice." So the basic principle is that nobody should be deprived of any basic rights which are enshrined. So all should be treated equally, and also the rights which are available for everybody, that is, they all should be equal. Nobody is above law, including the king. And also regarding the local laws, which was because they never had any written constitution. And these words are so important for that walk of judiciary has taken note of the Magna Carta clause 39 throughout. Then the second one, which will be of some significance and very important, is Sir Edward Coke. What he has said in 1628 was that Englishman's home is a castle. Can you believe? These were the original ideas of those jurists in those days, to state that everybody should be treated equal. Everybody needs a platform to put forth what they want to state. Nobody can be deprived of any right without a due process. So not only that, Pitt the Elder, again, took cognizance of this Magna Carta clause 39, and what he said was very interesting. This is really interesting and fascinating and amazing. I quote, "The poorest man may in his cottage bid defiance to all the forces of the crown. It may be frail, its roof may shake, the wind may blow through it, the storm may enter, the rain may enter, but the King of England cannot enter." Can you believe? That is, a person may even be fragile. He may even have a roof which is leaking. The water can enter, the storm can enter, the wind can enter, but then the king cannot enter without following the due procedure. So the due procedure concept was well understood and well taken forward as far as Britain is concerned. Now, the concept of this due process has walked to America. America, you all know, the constitution they drafted in the year 1787. And that's very interesting to note how they emerged into the making of constitution, because the America was just facing then a lot of issues pertaining to war, which it was waging against many people and also many countries, and they had internal disputes pertaining to sharing of the borders and then tax collections and a lot of issues. So the congregation decided that 13 states would get into the work of revising the constitution. The basic constitution which was available then, they will revise it and thereafter bring in something new so that it would suit the basic needs of the people. So this entire exercise was made in Pennsylvania, to be more particular. It was made in the state of Philadelphia. Pennsylvania state is very, very humid, and it was done during the time of spring. And people were asked, that is, out of 13 states, the quorum required was 8, but then in fact 7 of them attended originally, and thereafter they had to wait for a month, another person to join, that is the other state to join, and then they had the quorum. In fact, big educators, great educators all took part in the process of revising. Originally the thought was to revise the constitution which is available, but later they even stated that look, this is actually, it's all outdated, it's not even suiting the basic needs, so let's like scrap it and come out with the new concept, the new idea which we are working on. So it took 3 months for them, and you won't believe they are so conscious about whatever was happening. And those days, no air conditioning or no fans, but still they ensured that they wore their frog length coats and then high collared shirts and then thick pants, and in the humid weather they sat for 3 months and they drafted the constitution. This constitution, wherein the words due process are found, has undergone 2 amendments. One primarily being the 5th Amendment, second being the 14th Amendment. 5th Amendment, what is that 5th Amendment talks about? In fact, I can quote, the due process as far as America is concerned is just the same. That is, no man shall be deprived of his life, liberty, and then the property without due process. And also, Prithvi?
Yes, ma'am.
Am I audible? Okay. So the
Yes,
Fifth Amendment was applicable only to federal. That is, the federal law states that no person can be deprived of his life, property, liberty without due process. And what is that? It's different from 14th Amendment. You all may wonder, how is that 14th Amendment was brought in, and what is the basic difference? Nothing at all. It's just the same, verbatim, the repetition of the 5th Amendment, excepting for the word federal was removed, and then they brought in all states. Because each state had its own laws. One state may have a law which was applicable to them, which was different from the other state. So they said in the 14th Amendment that no state shall deprive a person of his life, liberty, and property without due process. So these are the basic amendments as far as due process is concerned. But then I'll just quickly take you all through few important judgments. The Plessy was the first judgment, which was like very, very interesting, because the concept of due process was considered there. And this is of the year 1896. And this judgment was rendered, in fact, there was a dissenting judgment by the John Marshall, the Justice John Marshall. Justice John Marshall has given he's coined a lot of unique words, which I'll take you all through. But then regarding Plessy, see, the New York, sorry, it's Louisiana. Louisiana had a law regarding the train cars, that is 2 different compartments. They had, the charge against him was that he got into the compartment which was meant for whites, and he never got into, he had access only to get into the train car of others. So that was primarily the charge against him. So he said, look, this is directly affecting, it's infringing my rights which are enshrined under Article Amendment 14. So you need to allow me. And he went to all the courts up to the Supreme Court. But Supreme Court rejected his plea. And it even stated that, all right, you are all equal, but separate. This was the connotation which was found there in the judgment. But there was a dissenting judgment. Plessy judgment in the dissenting note was by Justice John Marshall, where he said, very interesting, Constitution is colorblind. Can you believe he did say in those days that Constitution was colorblind? But then later this judgment was overruled in Brown versus the Board of Education. But before that, in between, I will just say regarding the procedure, that is the substantive due process. I'll take you all to that. That is, the due process had its own march upon other aspects, which I'll just take you all through. But before that, let me just complete the 2 other judgments. The second judgment would be Lochner versus New York, where It is relating to the baker. A baker, they had a law, Bake Shop Act, which had prescribed the bare minimum timings meant for the employees and also regarding the wages. But then there was an infringement relating to the extract of work from the workmen, not only the prescription which are found there in the act, but then they were extracted more work beyond the time which was prescribed. So a person, and they challenged it, stating that this is infringing on our right. Then the court said no. There is also a concept of contract. So contract act between two individuals, that is, they are subjecting themselves to the terms and conditions of a contract. So when eyes wide open, they have subjected themselves to the contract. Then you can't bring in that legislation was struck down, wherein they brought in. So for striking down that particular legislation, the concept which was brought in was substantive due process. I'll take you all to that. But the third judgment, which I was just telling you, the overruling of Plessy by the Brown versus Board of Education. This is of the year 1954, and the judgment was rendered on 17th May. This judgment is again very interesting. There again, the principle which was emerged, or which came up for consideration was, can there be two separate classrooms for whites and others? So the court said no. The legislation was struck down. The court said you cannot do this. This is against the 14th Amendment. It's infringing on the basic rights, and that's how they overruled Plessy. So these three judgments are only to show the amount of power what the court had as far as any legislation was concerned, and also relating to the basic rights of people when it came to application of due process. And not only that, the due process, as I said, it had its own walk relating to interpretations, can be in fact taken note of as far as two aspects are concerned. One being the procedural due process, second being the substantive due process. What is procedural due process? Procedural due process is the right of a court to have a judicial review on a person who is approaching the court, stating that, look, my right to that is my right to life or property or liberty is deprived, and I'm taken away of this, or there's an infringement apparently, therefore the court has to intervene. There again the court intervenes and then states that, all right, I'll look into it, provided the procedures which are contemplated under the act, are they followed or not? So when they look into that, they analyze whether the person was heard, whether the person had a fair hearing, and whether there is a judgment. So these aspects are by the authority. That is, in the sense, after hearing, there is application of mind by the authority, and is there anything in order or whichever is passed against him, and which will be considered by the court. That comes under the procedural aspect. Now, relating to suppliant attempt by the courts regarding the judicial review, where they get into the legislation as such, not only the procedural aspect, that is the law, whatever states, all right, it pertains to the procedures which are contemplated, all right, we find that everything has been followed. But the law itself, whether that such a legislation is correct or not, they get into the basic foundation of making of that law, and they even go to the extent of striking down any provision for that matter. So that's where the powers of substantive due process has emerged. In fact, now I can take you all to the so I have covered already three judgments, and then I've taken then regarding the substantive, this is very significant. Substantive due process, in fact, they have categorized into, it's a three-tier mechanism. First being the rational scrutiny by the court, and then second being the intermediate scrutiny, and the third being the strict scrutiny. So what is rational scrutiny? Rational scrutiny, I would put it, rational review by the courts. That is, they see whether is there any rationalism behind the attempt made by the government to achieve what they want to. So they kind of look into the real object or a reason for a legislation being brought up, and then they decide the case relating to striking down of a legislation. Secondly, the intermediate is being which is more of balance and check between the want of the law and then whether is it suiting the larger public, or what could be done. They try to find the mechanism, or that could be considered as intermediate scrutiny. And third being the strict scrutiny. This is very, very, facet. Strict scrutiny where the government is put on notice upfront, stating that you need to state why you need this law, and whether is there really any reason for you to, compelling reason. The words which are in fact found in those judgments are the compelling reason. Whether do you have any compelling reason to bring in such a legislation, and also is it tailored in a fashion that it's going to suit the purpose which they're trying to achieve, and also is there any excessive demand which is made. That is, for example, I can give an illustration. We can take our lockdown now. We can say for 2 weeks people can be denied of assembling for 2 weeks. We can state so. The government can state so. But can they state that we can deny an assembly for 5 years? That will be something beyond their powers. The court will definitely intervene to see what is the real intention behind this whole legislation, which is that's just an illustration. And now I have covered as far as American Constitution is concerned relating to the amendments, and then thereafter the judicial review relating to due process as such, whether it is not only stopping to procedural, it even takes the power for substantial due process. Now coming to our, that is the walk from Britain to America and from America to India. India, you all know, Indian Independence Act, Section 8, by which the drafting committee, that is the Constituent Assembly, was formed. And Dr. Ambedkar, B.R. Ambedkar was the chairman. And they had a lot of deliberations and discussions relating to how the constitution can be framed. In fact, they had their own original thoughts which were put into, because we were divergent and we had a lot of raises, and we had to always keep in our mind that we have to, the draft should kind of suit everybody's needs. That was the prime object. So not that they had their own innovative ideas into it, they also borrowed many concepts from various other countries, like Irish, the Directive Principles of State Policy. If you just see part 3, in part 3, the Article 21, which talks about the right to life, liberty, in fact, wherein we even brought in the concept of personal liberty. It is a concept which we took from Japan. Japan, they were just 1 year older to our constitution. And Article 31, we brought that into our constitution. And the fourth part being directive principles, I will not take you all to that, but then now I'll confine only to Article 21. So 21, there was deliberation, as I said, regarding incorporation of due process. Can there be the words due process in the articles, or can there be any other word? So the Constituent Assembly, in fact, there was a drafting committee, and a very senior person in the drafting committee, Mr. B.N. Rao, was sent to America, and they wanted to explore the possibilities of bringing in the concept of due process to India. So when he was sent on that job, he's an ICS officer. You all know those days at the Britishers, it's only Indian Civil Services, which is now equivalent to our IAS. So he had gone all the way, and he met up with the jurists there. And then it's very strange to find from between 1899 to 1937, they had about 200 legislations which were set aside by the American courts. So that really rattled Mr. B.N. Rao. And in fact, he met Justice Felix Frankfurter. Justice Felix Frankfurter stated that this powers which are being given to the court to intervene in any legislation it was actually a headache for them. I put it in a lighter way. Therefore, he said, India being a colony and under the Britishers, wherein we can look for something different. Then Mr. Rao comes back. In fact, during the deliberations, the attempt was to squarely apply due process. And also they had another concept, procedure established under law, by law. So they said either due process or the procedure established by law. Which will we have when it came to depriving of a right of life, personal liberty? How we can incorporate these two words? So the debates, in fact, the debates are available in many, online also it's available. You can go through those. It's magnificent. It's like the amount of knowledge which has gone into, but which are very, very important and apt for today's discussion. I will just take you all through. In fact, regarding the discussion, one very, very important discussion wherein Sir L.R.D. Krishnaswamy Iyer, he in fact wanted the rules established by law. He stated he was able to foresee that if you have to give due process, then the rights will be all the time deprived, and every time when it's being deprived, it'll all be taken taken to the courts, and courts will intervene, and the legislations will be questioned. So he said, he actually voiced for rules established by law. That is, when you deprive a person of his rights to life or personal liberty, you need to follow the rules established by law. So this was the article which was brought in. Now, consciously, the framers or the founding fathers had left the words due process as far as our constitution was concerned. But today, when we look, we are having this concept of due process. How Article 21 is even being read by Article 14 and also Article 19. Oh, where did we get this concept of due process? There again, the court's intervention. That is because the fabric, as I said, the constitution is a document which has life, and it sees everyday's requirement. It sees what are the needs, and it sees is there any blatant violation of the basic fundamental rights. So that's when the advent of the judicial jurisprudence comes in. So now I'll take you all quickly to the through the judgments. The judgments are very, very interesting. The first one would be A.K. Gopalan, where relating to the powers of the court, wherein whether did the court intervene in terms of infringement of a personal right. That is, a person was, it's a case of a preventive detention. You all know A.K. Gopalan, the CPIM leader, was detained, and his main plea was that I was not heard before a detention order was passed. So it's affecting my rights under Article 21, right to life and right to personal liberty. Therefore, it should be set aside. But the court refused. It stated that we have to just go by the provisions which are contemplated under the Act. The article states that you need to, this is the procedure. The procedure has been followed, and you can never be found that there is any violation relating to the procedure. Therefore, the order is right. But there was a dissenting judgment by Fazal, Justice Fazal Ali, and that later it was the walk of due process. In fact, I would say it all emerged from that decision of dissenting decision. But the second famous judgment would be Menaka Gandhi's case. You all know Mrs. Menaka Gandhi was the daughter-in-law of Mrs. Indira Gandhi, then Prime Minister. And she had to address an international conference in Italy, and then there was an action taken against her by impounding her passport on the ground that she had infringed on somebody's privacy by writing an article against that person. So they invoked section 10(3) and her passport was impounded. But there again, they followed the procedure, what was contemplated in the Act scrupulously. They had put her on notice, she had replied, and then the order was passed by impounding her passport. So then she challenged it, and she said, this is squarely, it's violating my basic rights, my fundamental rights, and this can never be done. And the court actually, there for the first time, read Article 21, not only Article 21 in its exclusiveness, it also read relating to Article 14, which is equality, and also 19. So I would say the emergence of due process, which was not found in the constitution, started for the first time, or the second time, I would say dissenting judgment, I'll leave it, for the second time, in the judgment of Maneka Gandhi. The test of reasonableness for the first time was even considered by the court. And it has to be in confirmation with the Article 14. In fact, there are other judgments which I can take you all through, because slightly there was a tilt from the basic principle, that is the basic traditional approach of a court, got tilted towards the other aspects. And that's a very good development, because the development in the sense, the court had powers to see whether is there any real reason for the government or the authority, because everywhere, if you just see, there could be possibility of executive being excessive and their action being excessive. So that's when the concept of reasonableness, or understanding what is Article 14, what is enshrined, and how is it being deprived, is it really made with any malafide intention? So these concepts all started to emerge. That's how today we have got due process as far as our law is concerned. In fact, after Maneka Gandhi, the law, which I was just telling you, got tilted. It's now both ways, that due process can be incorporated apart from the rules established by law. And there are also some judgments which stated that no, exclusively it is only the Article 21 which says rules established by law. You can't bring in the new theory of due process. The judgments are the doctrine of, in fact, very famous judgment, A.S. Krishna versus State of Madras. It's reported in AAR 1957, Supreme Court 297. It stated that doctrine of due process has no application under Indian Constitution. So this is the first, in fact, the judgment which categorically, in black and white, stated that we have no business of having due process as far as our Constitution is concerned. Then, regarding declaring any legislation as unconstitutional, that also McDowell Company case, which was later followed in Raj Balla's case. Raj Balla's case is rendered by Justice Chalmeshwar, Honorable Justice Chalmeshwar. And there, if you just see, it's reported in 2016, Volume 2, SEC, page 445. In that, the power of the court to strike a legislation as being arbitrary, they said no, we have no powers to, because the due process concept was not available, is by and large the reflection of the judgment. But I should always keep in my mind, because I have just taken you all through the walk, but now today's actual position is something which is very fascinating to note, that Justice Nariman, in two decisions which are very, very significant. The first being Muhammad Arif, which is reported in 2014, volume 9, SCC, page 737. And I quote, "Wheel has turned full scale. Substantive due process is to be applied when there is a threat to fundamental rights and liberty." I unquote. Justice Nariman, in a beautiful manner, has explained that we have, all right, what is the real requirement? We can't stick to the same old principles which are found there, stating that the Constitution has only the rules prescribed by law and we can't have due process. No, we have seen so much. We need to test any action taken by the authorities, whether is it infringing directly the Article 14, and also the reasonableness, and also the making of the legislation, whether is it suiting. So the change, in fact, the tilting from Maneka Gandhi has just come again to the concept of incorporation of due process. And not only due process, it has also gone to the extent of substantive due process. And same Justice Nariman, in triple talaq case, you all know, upheld again regarding the action taken by, in terms of the the legislation as such, he has tested it on the principle of violation of Article 14. So this is the march of life, because as I said, the Constitution has a life, or it's a living document of due process from various countries to our jurisprudence or our laws concerned for today. And to conclude, I would state the action of every authority is tested, no doubt about it. And they follow the rules and they follow the procedures. And they may even follow the procedures scrupulously, no doubt about it at all. It is followed. But the court's interventions would be, it ought to be followed. So there they see what is the meaning of ought. That is there any blatant violation in terms of the fundamental rights which are enshrined? Because today, if you see, the rights are not only the basic right of life and liberty, personal liberty. It is also the basic human dignity. We have walked through so many decades to bring in this concept of basic human dignity. Basic human dignity means what? A person should be promised of living for today, and not only today, he can look forward for something for tomorrow and a better tomorrow. This is what is the basic, down the line, if you just see what is the concept, this is the concept. And not only that, one more aspect which it just skipped my mind, regarding Article 21. 21 does not only apply for the citizens of our country, it even applies to people who are available here. That is, if the foreigners, if they come here, the same treatment needs to be given to them, and they will also be enjoying the same law. In fact, that has been well founded in the decision rendered by Keher. I will, in judgment, 1 minute, I'll just refer to that. It is the judgment which is found in, I'll just give you all the citation. So I think I'm done for the day. I hope I did cover the basic principles, and the question relating to, it's actually the judgment related, it's reported in 1989, volume 1, SEC, page 204, Keher Singh versus Union of India. And also there's a reference about Chairman Railway Board and Chandrayan Das. This is also relating to the law which is available for others who are non-citizens as far as Article 21 is concerned. So the basic structure relating to Part 3, which are the fundamental rights, are available to the people who are here, and in the sense when they come here, it's equal to all. So with this, I conclude my talk, and any queries, please, you can go ahead.
Thank you very much, ma'am. I think there are a few questions which have already come up in the chat box. So with your permission, ma'am, we'll just start off with the question answer session.
Sure. Go ahead.
And ma'am, there is a request, like a few citations we were not able to note it down. So at the end of the session or later, you can just share those citations with Aparna ma'am.
Definitely, the citations are, I had actually referred to American law relating to Plessy, Brown, and then, I can give you those judgments, no problem.
If you can share it with me, ma'am, then I can forward it later on.
Definitely. That can be done.
Thank you.
That shouldn't be a problem.
Thank you very much, ma'am. So, ma'am, first question, Mr. Srinivasa Raghavan wants to just ask me. I'll just unmute him.
Yeah, go ahead, Mr. SSR.
How are you,
Mr.
Narmada,
Srinivasa, if you
I'm
can
doing
hear
good.
me?
How are you doing?
Yeah, I'm fine, doing well.
Hope all well.
Yeah, everything is going on well.
Doing a great job of having this webinar and Zoom, keeping everybody on their toes.
That's really nice.
Very glad. It's very heartening, because during the lockdown we just kind of sulk, and we really don't come out of.
That's really nice of you, and I don't want to become a stale object, so that everybody keep engaged. It's the purpose of.
That's good. That's a very, very. In fact, Hemalata also should be appreciated for that.
Yeah,
it's a good gesture of,
Thank you. Thank you. And I have one question, Narmada ma'am. So
Yeah,
you beautifully what is called describe the origin of the world due process of law and how in Indian constitution we have got our own context. My one doubt is I have gone through a volley of judgments regarding Article 21 vis-a-vis the DNA test. Before 2014, until Justice Kehar has declared DNA test can be a proof of non-access, Indian courts were a little bit not inclined to accept a DNA test because what was standing between the courts and the parties was the what is called without due process of law. There can be no test against a person like taking a voice sample or DNA test or blood sampling. How to reconcile, because what a person wants to do in under Article Section 112 of the Evidence Act
that's
is to
what I
give.
said. At the risk of repetition, Mr. SSR, I was just telling you the slight tilt towards the law as far as what was there. I would put it like conventional law has, as Justice Nariman has put it now, the wheel has its own full scale. So it's all like kind of tilting. So basically, any legislation which is made or enacted will be tested on the question not only pertaining to Article 21 and also pertaining to 14 and 19,
19.
and also regarding the reasonableness and equality. So this is just jurisprudential. I mean, in fact, the debate would be whether do they even have a power. But I'll just leave that open. I'm not even discussing on that
Okay.
because the debate continues.
Yeah.
So it's all on the interpretation of that particular legislation, and also regarding the facts of each case. It differs.
So I can say the debate is on.
Yeah, debate is very much on. I should have just stopped my talk by, quoting that one single phrase. I should have stopped, or
That's
I should have concluded.